Analysis of the U.S. and state court system. Before examining the court system, we need to know the main difference between the different courts. Original jurisdiction refers to the power of the court to hear a case for the first time. The case in question must have specific qualifications that meet the court it is being heard in. Appellate jurisdiction refers to the power of the court to review and possibly overturn cases from lower courts if the higher court sees an error made in the court hearings. This can range from an unfair trial to an unconstitutional decision.
Trial courts refer to courts where most criminal and civil cases are first heard and tried. In trial courts, a judge presides over a case where lawyers and prosecutors present their case through physical evidence and witnesses to a jury, who then decide whether the person in charge is guilty or liable to charges. Most trial courts have original jurisdiction since most of the cases start in the trial courts. Trial courts are usually divided based on the types of cases they can hear. They either have general or limited jurisdiction. General jurisdiction refers to the court that can hear any case that doesn't involve a specific court, while limited jurisdiction can only hear a few cases that meet certain criteria.
Appellate courts are courts responsible for overlooking decisions and appeals made by the lower courts and possibly overturning certain decisions that are unconstitutional. Usually, the appellate courts have a panel of judges who evaluate and make the final decision on the case. Since the appellate courts review cases, they have appellate jurisdiction as well. Now that we've finished the basic overview of the different types of courts, where are these courts in the U.S. government system? As seen with the diagram, it represents the different levels of courts in the United States, but we're going to look at the state trial court right now.
State district courts effectively act as trial courts in the state court hierarchy. Each state district usually has at least one judge who presides over cases that involve a decision made by a jury, evidence, and testimony.
After the state trial court, it can possibly go to the state appeals court if the loser sends an appeal to the state appeals court.
State Court of Appeals acts as the intermediate appellate court in the state, overlooking the decisions made by those in the trial court. In Georgia, there are 15 judges who serve in 5 divisions, meaning that 3 judges in each division review cases that meet certain criteria.
If someone is dissatisfied with the decision made in the state appeals court, he or she then can appeal to the state Supreme Court, the highest level of court in the state level. The state Supreme Court acts as the highest appellate court in the state level, meaning that it reviews cases and questions the constitutionality of certain decisions made. Next, we'll look at the U.S. district courts, the first level of courts in the federal court system.
Federal district courts are usually the trial courts in the federal hierarchy of courts as judge presides over cases that involve juries and witnesses. There are 94 federal district courts in the United States, each aided by magistrates and appointed judges. The main difference between the federal district courts and the state district courts pertain to the type of cases that each court could allow. For example, state courts would take most of the cases today, divorce, criminal and traffic violations, while federal courts involve cases that break federal law and include a feud between 2 people of different states.
After the U.S. district courts, one could then appeal to the U.S. Court of Appeals. The Federal Court of Appeals acts as the intermediate appellate court in the federal court hierarchy, overlooking decisions made by the trial courts in their district. In each review case, usually there would be a panel of 3 judges who would judge whether the court trial was fair or the decision was unconstitutional. Finally, the highest court that one could appeal to is the Supreme Court.
The Supreme Court of the United States acts as the highest level in both the federal and the state court. Usually, one has to have their cert accepted for their case to get accepted in the Supreme Court. 9 justices occupy the Supreme Court, in which they both have appellate jurisdiction and original jurisdiction depending on the case.
The Supreme Court does have original jurisdiction in cases involving land disputes between 2 states, but they are more likely to exercise appellate jurisdiction over cases of federal law and constitutional legitimacy. The Supreme Court also has the power of judicial review, which allows to declare certain laws and executive orders unconstitutional as necessary. But how does one ensure that they are protected from the unlawful actions in court? Due process ensures that it protects the rights of Americans by making sure no court acts above the law and that every citizen has fair treatment under the law. Citizens cannot be proven guilty of an action unless proven through the trial system. Equal protection prevents discrimination from the court system by ensuring that all citizens have equal protection under the law.